Good morning again, everyone. Welcome to our third and final webinar on immigration. My name is Michaela Stone. I'm a legislative analyst here at CSAC in the Administration of Justice Policy Portfolio, alongside my colleague here today, Ryan Moramini. We're joined by Monterey County Supervisor and CSAC's second Vice President, Supervisor Luis Alejo. Supervisor Alejo, welcome. Take it away.
Yeah, good morning, and to all our CSAC family. I'm Monterey County Supervisor Luis Alejo. I'm your second Vice President of the association, and I want to thank CSAC and our dedicated staff, Michaela and Ryan, for organizing the last of this three-part webinar series on the complex and controversial topic of immigration. We know that there are new developments almost every day as we see it play out on our evening news. We heard from many county supervisors and county staff who wanted to better understand how immigration will impact county governments under the current administration, and what are those key aspects that we should be aware of. Here in Monterey County, our efforts over the last 3 months have really focused on working collaboratively with local stakeholders in law enforcement, agriculture, hospitality, our local school districts, nonprofits, hospitals, and many other sectors of our county. We also focused on community education efforts so that our residents and small businesses were informed about their rights, and we held our largest ever town hall in our county's history with over 800 people in attendance. But we all know that there have been similar efforts in many of your counties across the state. Our first webinar gave an overview on the national landscape on immigration. Our second series focused on executive orders and some of the legal actions pending in federal court. And those cases continue to roll out each week. Just yesterday, the Supreme Court ruled on litigation pertaining to a mistaken person who had a pending asylum case but was mistakenly sent to a maximum security prison in El Salvador without due process. The High Court ordered the administration to facilitate his return. This week, there are new developments with the Social Security Administration potentially revoking tens of thousands of valid Social Security numbers granted legally to persons with temporary legal status, and that would have an impact on thousands of residents and their employers across our state. On our topics for today, I want to thank our expert speakers who have joined us from the California Department of Justice and my former dean of UC Davis School of Law for sharing their insights on existing state law under Senate Bill 54, how state law interacts with federal immigration law, and also existing guides for local governments. Lastly, I want to thank you for joining us for one or maybe all three of these webinars. This was the first time that CSAC held such a series with renowned experts from across the country on immigration, but we know that this is an issue that is not going away and will continue to have an impact on the work we provide each and every day in county government in the years ahead. With that, I want to pass it back to Michaela, and thank you very much for joining us.
And now, before we jump in, I'd like to introduce our esteemed speakers of the day. So we have Jaclyn Gonzalez from the California Department of Justice and Professor Kevin Johnson from the UC Davis School of Law. Jaclyn Gonzalez is a Special Assistant Attorney General for Immigration Matters at the California Department of Justice, a graduate of Harvard and UC Berkeley School of Law. Jackie has advocated to the legislature on matters relating to immigration. She's played an instrumental role in building 2 of the leading removal defense teams at nonprofit agencies in the state and has led strategic initiatives to secure needed legal support to under-resourced immigrant communities throughout the state. So thank you for being here today, Jackie. Our other speaker today is Professor Kevin Johnson, who is a distinguished professor of law, a Mabee Apellis Professor of Public Interest Law, and a Martin Luther King Jr. Professor of Law. Professor Johnson also has an appointment as a professor of Chicano Studies at UC Davis and joined the law faculty in 1989 to be named Associate Dean of Academic Affairs by 1998. Professor Johnson has served as Dean at UC Davis School of Law for close to 2 decades and has taught a wide variety of classes, including immigration law, civil procedure, and complex litigation. So with that, Jackie, I will pass it to you for our first presentation. Thank you both for being here today.
Good morning, everyone, and thank you so much for the invitation and the opportunity to share some information today with you. I will be speaking largely about model policies issued by the California Department of Justice. Before launching into the 2 that I will cover, I did want to just present a brief overview of why these policies exist and the California Values Act. I won't get deep into that because I know that Professor Johnson will be speaking in more detail about the Values Act later. But just briefly to level set, the California Values Act otherwise known as SB 54, is a law that was enacted in 2018 that really highlights the importance of ensuring that public agencies remain accessible and really outlines the contours of how public agencies can interact with federal immigration enforcement in our state. There was a recognition at that time that the relationship of trust between our immigrant community and state and local agencies is threatened when state and local agencies are entangled with federal immigration enforcement. So for the purposes of my presentation, while the law does many things, one of the critical things that SB 54 calls for is the promulgation of model policies and guidance that limit assistance between immigration enforcement and local agencies to the fullest extent possible under the law. So the law calls for guidance to be issued for shelters, libraries, health facilities, labor agencies, courthouses, colleges, and K through 12 schools. I will note that it is required for all public schools, health facilities, and courthouses to implement these model policies. And the model policies must be substantially equivalent to those issued by the California Department of Justice. So other agencies like the ones I mentioned, shelters, libraries, they're encouraged to adopt these policies, but they're not required under the law to do so. Along with SB 54's call for these model policies, California also enacted Assembly Bill 699, which prohibits school officials and employees of a school district, county office of education, or charter school from collecting information or documents regarding citizenship or immigration status of pupils or their family members. So SB 54, along with AB 699, as we will discuss a little bit later, really help outline the contours of the model policies for K through 12 schools. SB 54, as I noted, it does mandate the adoption of policies for certain institutions. These guidances that we'll be discussing today, they set a minimum for what must be adopted, but SB 54 does, I want to note, give local jurisdictions the ability to enact their own protections as long as these don't conflict with SB 54 and are as equal to or greater than. So again, the model policies that we'll be discussing for schools and courthouses establish a baseline, but certainly if there are jurisdictions that want to add additional protections, that is permitted. There are a couple of laws and general principles. We discussed SB 54 that sort of serve as a backdrop and have sort of like a common thread throughout the model policies and guidance. We discussed SB 54. 8 USC 1373 is a really important section of federal law to understand. It mandates that, and as currently construed here in California, that a federal, state, or local government entity may not prohibit or in any way restrict a government entity or official from sending or receiving the citizenship or immigration status, law, or unlawful of any individual. So that specific section has been interpreted by the Ninth Circuit here as it pertains to California in a pretty narrow way. And essentially it says that 1373 only pertains to immigration status or citizenship status. So this means that if ICE were to ask any public entity about a particular person's immigration status under this section, the state or agency head cannot limit the public entity's ability to answer that specific question if it knows the answer. So that's the critical piece, if it knows the answer. Section 1373 does not mandate, importantly, does not mandate the collection of immigration status information. Number two, it does not mandate the retention of immigration status information if it is collected. And it does not pertain to groups of people. So for example, the federal government asking for a wholesale response about immigration status about a grouping of people versus making an inquiry to an agency about an individual. So I highlight this as a backdrop because a lot of the model policies and suggestions like that are included in our guidance sort of acknowledge that that Section 1373 does allow for the collection specifically of an individual's immigration status if requested. But to the extent that agencies want to try and curtail or limit, federal immigration enforcement collaboration, there are ways to comply with 1373, but also protect individuals who are accessing services who may not have lawful status. And finally, I do want to touch on the ICE protected areas memo, also colloquially known as the sensitive locations memo. If you're not familiar with this memo, essentially for many decades, and including most recently under Biden, there was a memo issued under his administration, but that was also in existence in different iterations in prior administrations for decades, which essentially says that ICE will limit its enforcement activities at what are otherwise known as sensitive locations, which you can imagine include places where the community and individuals, excuse me, access public services, critically education, schools, places like courthouses. There is actually a separate memo for enforcement activities at courthouses. And unfortunately, since the issuance of the guidance that we'll be discussing today, both of those memos, which would curtail enforcement activity at these various locations, have been rescinded by the current administration. So I do want to highlight that because the guidance and policies, they are accurate to the fullest extent of the law at the time that they're issued, which in this case was in late 2024. But as I just shared, the certain memos that protect individuals at these locations were rescinded. Notwithstanding the rescission of those memos, it's very important to understand that there are a lot of California laws that provide for protections at state public agencies and local public agencies, and that also there are constitutional principles, specifically the Fourth and Fifth Amendment, that continue to provide protections to individuals regardless of immigration status at these locations. So that's just a caveat to say that wherever in these guidances you do see references, to policies, it's very important to understand that to the extent that there have been changes, as I just mentioned with these specifically, or other changes in the future, perhaps the reinstatement of a sensitive locations memo, it's important to read those guidances with that understanding. So with that backdrop, I'd like to transition. We'll be covering two policies. Like I mentioned, there are many guidances that have been developed, but I wanted to just touch on two today in the interest of time. The first one that we will be covering is the school K through 12 guidance. And in this context, I really want to highlight the importance of California public schools for all Californians, including our immigrant families and children. And state educators have really an incredible opportunity and responsibility to create and maintain secure and peaceful learning for all students, regardless of nationality or immigration status. As I mentioned earlier, AB 699, in addition to SB 54, mandates that the AG publish model guidance that limits assistance with immigration enforcement at our public schools to the fullest extent possible under the law, and to ensure that these spaces remain safe and accessible to all California residents. So the model policies that the AG's office has issued do a variety of things. First, they provide a summary of laws that govern the collection and protection of student information, including immigration status, social security number, and enrollment information. In that context, there are many laws, so I obviously will refer you to the guidance, but there are 2 points I wanted to highlight. The first is that California law bars school districts, county offices of education, and charter schools from collecting or soliciting social security numbers or the last 4 digits thereof from students or their parents or guardians, unless otherwise directed to do so by state or federal law. This is, as Supervisor Alejo mentioned at the inception of this call, the data collection and information sharing and that is occurring right now is unprecedented. And so we just saw some, news about the IRS and the sharing of Social Security numbers. And so I felt that highlighting this particular point was critical. The second is what can be collected during the student enrollment process. And again, here, while we know that school districts must verify certain information, including, for example, a student's residency in the district and their age, California law actually requires school districts to accept what is known as reasonable evidence of residency in the district. And state law provides a list of the types of documents that school districts may accept. These are really meant to be comprehensive and to facilitate the enrollment of a student. And it provides a lot of ways to verify in district residency that doesn't necessarily implicate sensitive personal identifying information, for example, such as a social security number. With respect to age, schools also permit a variety of documents for proof, and local education agencies, for example, cannot bar or discourage a child from enrolling in school simply because they might lack a birth certificate or because they may have one, for example, from a foreign country. And in this regard, as we're discussing with respect to Section 1373, even when certain information is collected, for example, to verify age, there isn't a requirement in that context for a school to retain a copy of the document that was used to show age, which again is very critical when you consider the information sharing that takes place and that may be requested under the law from a school. So there are a lot of different examples of documents that can be used that govern the collection and protection. And so those are just a few of the examples. The second thing that the K through 12 guidance offers are model policies regarding this retention of student information. And one of the most critical things I want to highlight in that regard is that local agencies should avoid seeking or collecting information regarding students or families' immigration status, again, unless required by the law. And I highlight this one because, as we discussed again with Section 1373, if you collect the information, and there is a request made for individual information about someone's immigration status, and a local agency has it, then it would mean that they may then perhaps be obligated to respond with that information. But if there's certain information that you have, that if you don't have, then you cannot respond. So finally, the summary of laws and model policies instructing school districts on ways to protect against the release of information. So the guidance offers some suggestions. One of the suggestions offered is that parental or guardian consent be obtained before a school can share immigration status information with ICE. And it also provides a very comprehensive overview of how schools can respond to either requests for access to facilities or requests for student information. And this section of the model policies is, I think, one that we have seen has been very valuable. It's obviously a very complicated area of law, but the model policies and guidance really go into and provide copies and examples of the different types of warrants that an immigration enforcement agent may use when trying to access a school. This includes ICE administrative warrants, federal court warrants, administrative subpoenas, and judicial subpoenas. So the appendix to this guidance provides samples of what those different warrants look like. Again, it's a very complicated area of law, but I do want to briefly touch on the different warrants and sort of what is required when presented with that type of warrant. And these warrants and how to respond to them are included in nearly all of our model policies and guidance. And when we discuss the courts, I will highlight there that also this is included in that information. Essentially, the most common warrant that ICE will present when trying to execute an enforcement action is an administrative warrant. And an administrative warrant authorizes an immigration officer to arrest a person that they're suspected of violating immigration laws, but it doesn't grant them or any special power to compel school personnel to cooperate with the request. So an ICE warrant, importantly, does not authorize access to non-public areas of school grounds. So if an ICE officer were to show up with an administrative warrant and seek access to an area of the school that otherwise wouldn't be accessible to the public, school personnel can deny access to entry to that officer. An ICE warrant also does not allow immigration officers to search school records. So, of course, local education agency personnel should never interfere physically or obstruct an immigration officer in the performance of his or her duties, but they certainly do not have to allow their entry if they don't have the appropriate warrant for entry. And so a federal court warrant, so turning to a different warrant that would require compliance, a federal court warrant, which is a warrant issued by a judge of a U.S. District Court based on the finding of probable cause, that would authorize the search or seizure of property, the entry into a non-public area to arrest a person named in a warrant, or the arrest of a named person. Compliance is required there. And so in this instance, and again, these are, I really want to acknowledge that were something like this to take place at a school, we understand this is an extremely stressful situation. And while people may be trained, school officials may be trained on their rights, the exercising of those rights in a moment of stress can be difficult. And so you will see a common thread through the model policies and guidances that we have, which not just for identifying and understanding warrants, but also to really provide the opportunity for whoever the frontline staff is to have someone to call. You will see that we recommend there being a designated official, right, to local education agencies, that they can confer with their legal counsel if they are presented with any type of warrant to determine whether it's an administrative warrant, a judicial warrant. There is also the possibility of being presented with a subpoena, either an administrative subpoena or a federal judicial subpoena. And subpoenas are different than warrants in that they are essentially a request for the documents or the production of documents. And like an administrative warrant, an administrative subpoena, immediate compliance with an administrative subpoena is not required. So if an officer were to arrive with this type of subpoena, the local education agency could decline to produce the documents and later challenge that subpoena. And again, this would be a moment where it's important to have a protocol so that your personnel could immediately contact the designated official once a document like this is received. A judicial subpoena would also compel a production of documents, but it does not, you do not need to immediately comply. And importantly, this is a document that could be challenged in court, a judicial subpoena. So again, that's really why it's important to have legal counsel to consult with if and when something like this were to occur at a school campus. The last thing I will say about the model policies and guidance with respect to schools is there are also some suggestions there for how to respond to detention or deportation of a student's family member. In the unfortunate event that something like this were to take place at a school, the policy, the guidance really highlights the importance of ensuring that there's accurate emergency contact information available at the school, and that there also be the development of a family safety plan. The guide does not encourage that family safety plan be retained at the school for obvious reasons related to data sharing, but that it be stored somewhere that is safe and available for the student to locate. So I won't get too far into this to be mindful of time. And again, these are really dense subjects, but given, the importance of courthouses in our communities as a place to access, justice, the guidance that California has developed for courthouses is really important. We have seen immigration enforcement actions at or near state court facilities really have a chilling effect on immigrant residents who need to access California's courts for a variety of reasons. The model policies, again, similar to the schools, really provide an overview of the law, what's required in these instances of immigration enforcement actions, the importance of designating what is a private space that would require a warrant to enter. The courts do also have additional protections for crime victims and children. With respect to juveniles, there's a lot of laws that limit information sharing because of the confidentiality rules that apply to juveniles in our system. So I would really encourage, again, like the schools, this is requisite that courthouses adopt these policies. They're certainly encouraged to provide additional protections. But again, notwithstanding the rescission of the sensitive locations memo, our priority is ensuring that residents of our state are able to continue to access these critical services in a safe manner. And to the extent that these institutions are able to adopt protocols, they really can send a message that they continue to be places where all residents of our state can access services without the fear of enforcement. So I appreciate the opportunity to present these guidances to you and happy to address any questions at the end of the hour. Thank you so much.
All right, Professor Johnson, without further ado, take it away.
Thanks very much. I'm very pleased to be here and to talk to you a little bit about California Senate Bill 54, which is also known as the California Sanctuary Law. Just by way of a little bit of background, and I think it's important, we know that under our U.S. federal Constitution, most legal power is in the hands of the states. And the Constitution of the United States creates a very limited federal government of what is called enumerated powers. Now, when it comes to immigration, it's important to remember that the federal government, the United States government, has the exclusive authority to admit and deport immigrants from the United States. And under the Supremacy Clause of the U.S. Constitution, federal immigration law is the supreme law of the land. Still, states, even though their role in immigration is limited, they have a very important role in enforcing laws that protect the health, safety, and welfare of all residents of the state, including immigrants. And that's why what we're talking about today is so important. Now, President Trump's administration has announced a mass deportation campaign and it has increased immigration enforcement efforts. I try to keep up with immigration law, and I have to say I've never seen anything quite like this in my lifetime. This is an administration that is making immigration enforcement a priority like no other modern president, and is taking the kinds of actions that we've never seen in the modern president. And you know this from just watching the news. We have an administration that's invoking the Alien Enemies Act of 1798, which was used to justify detention of persons of Japanese ancestry during World War II. But this act is being used to remove people from the country who are not given a right to be heard, have their day in court, or to present evidence to show, for example, that they have been provided authorization to stay in the United States. And as Supervisor Alejo mentioned, just yesterday, the U.S. Supreme Court dealt with a case of somebody who was wrongfully deported, wrongfully removed from the country, wrongfully separated from his family and friends, and ended up in a cell in a high security prison in El Salvador. Now, why do I go into this detail here? Well, I think it's important to remember that the impacts of these policies are felt by people who live in our communities. We have a significant immigrant population in California, and immigrants feel under the scrutiny of the federal government, in legal immigrants as well as undocumented immigrants, as well as U.S. citizens of particular ancestry, are afraid of getting caught up in the immigration removal system. And they're afraid of the federal government. And I can't really underestimate or understate the fear that exists in the immigrant community right now. And it's a fear of being separated from family and friends. And it's a fear of any interactions with government. Now, as I mentioned, state and local governments have a limited role when it comes to immigration enforcement. But still, the fear of any law enforcement, any governmental authority in the immigrant community at this time is high. So I think it's incredibly important to recognize, all of us to recognize, but especially governmental officials and employees, that this is a time of high tension, high anxiety, and a great deal of concern. I've participated in Know Your Rights sessions, and I have been told that, some people in our community, some residents of our community, are worried about taking their kids to school, going to the doctors, going to church, going outside the house because they're worried about what might happen if they end up encountering law enforcement or federal immigration authorities. And I don't need to say that's no way to live, but that is a way that some members of our community are living today. And I think it behooves all of us to know and be aware of the high tensions and to be aware that these federal immigration enforcement efforts are having impacts on people who live in our community. And I do think it's fair to say that the Trump administration has been and will continue to pressure state and local governments to assist in these immigration enforcement efforts and to participate in federal immigration enforcement. I'll talk about, and we've heard it a little bit already, about limits under California law on state and local assistance, but there's still going to be pressure from the federal government to assist in immigration enforcement. And I do think we have to be aware that there will be some enforcement actions in our communities done by the federal government. In the first term of President Trump, there were immigration and custom enforcement officers who arrested people at state courthouses. We just heard about the possibility of operations in courthouses. Well, the last term, there were operations in courthouses. And one of the alums of the law school where I work, UC Davis School of Law, then Chief Justice of California, Tani Cantil-Sacayue, protested the use of courthouses as enforcement places and sent a letter to the Attorney General and the Secretary of the Department of Homeland Security protesting the enforcement measures at places where people seek to secure justice, where people seek to do their judicial business, whether it's getting a business license or a marriage license or paying off a traffic ticket or anything like that. Now, in California, we heard about this, we have a sanctuary law, SB 54, Senate Bill 54. Its official title is the California Values Act. It was signed into law in 2017 and went into effect on January 1, 2018. And the law prohibits the use of state resources to assist in federal immigration enforcement. And it tries to separate out, to the extent possible, state governmental functions from federal immigration enforcement functions. And the reason for that is that some observers and some political leaders believe that the separation of state agencies, including state criminal law enforcement, from federal immigration enforcement helps to get immigrants to cooperate with government and local police. If it is thought that local police are cooperating with federal immigration enforcement authorities, it's much less likely that immigrants, including undocumented immigrants, will report crime, be willing to serve as witnesses in criminal prosecutions, or will have anything to do with criminal law enforcement. And we need the help of everybody in our community if we want to address issues of crime and prosecuting people who commit crimes. So we in California call for a little more separation between state law enforcement and federal immigration enforcement. Other states have very different laws, very different policies, very different views about working with immigrations and customs enforcement. Florida and Texas, for example, are two states that are very willing to cooperate fully with federal immigration enforcement authorities. In Florida, for example, many local jurisdictions have entered into agreements with the federal government. They're known as Section 287G agreements. And under these agreements, which are allowed for under the Immigration and Nationality Act, local police agencies can assist federal immigration enforcement and work with the federal government in enforcing the immigration laws. Such agreements are very popular in Florida, and basically every county has a 287G agreement with the federal government. In county law enforcement officers are required to receive training if they're going to participate in immigration enforcement. Now, the Values Act, that's the law, the California Sanctuary Law passed by the California legislature, does not permit local counties to enter into 287G agreements. Now, even though we have this California law, SB 54, it's important to keep in mind, I mentioned before that the federal government has supreme power over immigration enforcement. And even if we have a sanctuary law and declare ourselves to be a sanctuary state, state and local governments cannot halt federal immigration enforcement. Doesn't need to cooperate with federal immigration enforcement, but in the end, it's the federal government that has control over immigration enforcement. Now, the first time that President Trump was in office, he and his administration challenged in court in Sacramento, the Eastern District of California Federal Court, and challenged the constitutionality of the Values Act. Now, that challenge failed. The district court rejected the claim that the California law intruded on the federal power to regulate immigration, and a court of appeals, which was one step below the U.S. Supreme Court, held that the district court was correct. California can decide how it wants to, if at all, participate in immigration enforcement, and the federal government can do what it thinks appropriate when it comes to immigration enforcement, within legal bounds, of course. Now, the court rejected challenges to the law. The Trump administration could again seek to challenge the Values Act. That seems unlikely, but I do think it's fair to say we're seeing President Trump continuing to push against state sanctuary laws. And in fact, yesterday, he was talking about decreasing funding to states that are sanctuary jurisdictions. He's not entirely clear what he means by sanctuary jurisdictions, but it's clear that he wants as much cooperation as possible by state and local governments with federal immigration enforcement. And President Trump already has threatened to cut federal disaster relief funding to jurisdictions, sanctuary jurisdictions, which got a lot of people's attention given the recent fires in the Los Angeles area. Now, I'll go over a variety of provisions of the Values Act, and I do think it's important that we follow the good guidance we received from the California Department of Justice. But local agencies risk lawsuits if they don't follow the Values Act. You can imagine a non-citizen who claims that the act was not complied with, suing, seeking injunctive relief, or perhaps even damages from a locality that violates the Values Act. And we've seen this in other jurisdictions at various times. Now, the federal government isn't so worried about whether it gets sued. In fact, the current administration apparently sees lawsuits as just a part of doing business. But most state and local governments worry about litigation, worry about the costs of litigation, and worry about basic compliance with the law. So I do think it's important to remember that these Value Act provisions are important to comply with and could result in litigation, which for most jurisdictions is not the optimal outcome. Now, what are the basic responsibilities of state and local governments under SB 54? Well, the California Values Act tries to ensure that no state and local resources are used to assist federal immigration enforcement. No state and local resources are to be used to assist federal immigration enforcement. The idea, and we've heard about this, the idea is, to the extent possible, make sure that California schools, hospitals, courthouses, public places are safe for everyone. Now, the ACLU has its own website talking about its view of the requirements of the Values Act. And in a set of materials that I've provided, and will be shared with you at some point, you can check out the sort of blueprint that the ACLU has for possible litigation if there isn't compliance with the Values Act. Now, some of the prohibited activities for state and local governments. You can't hold somebody just for immigration reasons. That's prohibited in the Values Act. You can't arrest people on civil immigration warrants. That's for the federal government, prohibited by the Values Act. State and local governments in California can't enter into Section 287G agreements. I mentioned that before, prohibited by the Value Act. State and local law enforcement agencies are not supposed to be asking about immigration status or using federal immigration officers as interpreters. Except as required by federal law, the Values Act prohibits sharing of personal information with ICE, such as home and work addresses. Now, this is an important one. State and local law enforcement generally are not to notify ICE of release dates of non-citizens, release dates from custody. There are exceptions designed to protect the public safety for non-citizens convicted of certain felonies, certain misdemeanors, or who have been charged with serious and violent crimes that a magistrate has determined there's probable cause that they committed. Now, if release dates, times are already publicly available, those can be shared with ICE. But if they aren't available, they can't be. Now, I do think that the advice we heard from the Department of Justice, which really is on top of this in ways that are quite commendable, the model guidance and policies really are worth paying attention to if you are very interested in ensuring compliance with the law and avoiding the risk of lawsuits. Now, in the end, in conclusion, I do think it's important that federal, state, and local governments pay attention to their role when it comes to the treatment of immigrants. What do I mean by that? I think that it's important that those governments stay in their lane. And in it's worth recognizing that different states have different approaches to their roles when it comes to immigration enforcement. California has declared its particular specified place under the California Values Act. And the Values Act represents the California legislature's response and limits to state and local law enforcement agencies' assistance of federal immigration authorities. And we've heard and seen California Attorney General Rob Bonta stating that California will protect its immigration and other policies to the extent possible from federal interference. The legislature has provided funding to challenge various immigration measures and to, if necessary, protect the California Values Act from legal challenges. But I think what I hope you take away from this is that we have a state law that limits involvement of state and local governments in federal immigration enforcement. And if you have questions about the various requirements of that law, it's a good time to ask questions and ask your counsel and get the appropriate guidance. Thanks very much, and I appreciate all your hard work. I do know that immigration is a hard area. Things are changing very much now, and it's in the news every night. Thank you very much.
Thank you so much for those remarks, Professor Johnson. We appreciate it. Okay, so at this time, we have concluded our presentations for our third webinar. So thank you all very much for everyone who joined us today, who may have joined us for other webinars. And we hope you have a wonderful rest of your day, a fabulous weekend, and we will see you all soon. So thank you very much.